because I'm gonna be absolutely honest with you. The way I am, if you had, I'd be so done.
From the very first second, Judge Simpson sets the tone with a blunt warning that slices straight through the courtroom air. And if you've ever watched this judge before, you already know. Honesty isn't just encouraged, it's demanded. And today, the defendant is walking into a bond hearing with one of the most chaotic case progressions we've seen in a while. What started as a simple misdemeanor spiraled into a felony-level mess, and somehow she managed to turn minor trouble into weeks behind bars, all because she could not, or would not, follow the court's simplest rules. This is the kind of case where every decision, every reaction, every violation ripples forward. The defense walks in trying to frame the narrative around counseling, mental health history, and personal struggles, arguing that with the right support, the defendant can stabilize. But Judge Simpson isn't here for creative reframing. He's here for facts, accountability, and a straight answer to the question he's already forming in his mind. Why should I trust you again? And trust is the entire foundation of bond. Bond isn't a reward, it's a contract. A promise to the court that you will follow instructions, show up, and not create new problems. But in this case, that promise has been shattered twice, maybe 3 times, maybe more, and everyone in the courtroom knows it. Before we dive deeper, keep this in mind. Today's hearing isn't just about modifying bond. It's about whether the judge believes the defendant can break her own cycle. As the defense brings mental health treatment into focus, the prosecution stays neutral but firm. And the judge, he's waiting for one thing: evidence that she won't walk out and repeat the same behavior. The tension is already forming. And trust me, by the end of this hearing, it's going to explode.
Court does call the case. People of State of Michigan versus Julie Van.
Good afternoon, Your Honor. Warren Green on behalf of Ms. Vongfachan. State your name.
Julie Vongfachan.
Your Honor, today's being for a motion hearing. Before the court is the defendant's motion to modify bond. Our motion is based on MCR 6.106. Your Honor, when we filed this motion, it wasn't our intent to try to distort the law or the facts to make an argument that somehow the court is bound to reduce her bond or grant our request. I think we know what the facts are leading up to this, and we know what the law is on whether the court can deny bond in such an instance. What we did was we laid out what we felt was a full and fair account of the actions leading up to this. And I don't think the people denied any of those actions leading up to this, just from a purely scheduling standpoint and from the standpoint of Ms. Vongfachan's bond violations. What I wanted to draw the court's attention to was that prior to Ms. Vongfachan's engagement with the criminal justice system in this case, she had previously engaged in behavioral health counseling. She was going to Apex Behavioral Health in Westland. I included the date in our motion.
The defense is leaning heavily into the defendant's behavioral health counseling, and strategically, this is smart, but only if the history actually supports a pattern of improvement. What the attorney is doing here is reframing her behavior not as defiance, but as a symptom of deeper issues she has tried to address in the past. Viewers, ask yourselves, does prior counseling help justify repeated bond violations? Or does it raise more questions about why progress didn't stick? Legally, mentioning past treatment can influence a judge's perception, but it cannot erase choices the defendant made after being placed on bond. Judge Simpson is fully aware of that distinction. He is not evaluating the past in isolation. He is measuring whether the defendant can comply today. The defense wants the judge to see her as someone who stumbled but is willing to try again. The judge, however, is watching for proof that trying is more than talking. This is where bond hearings get tricky. A judge must balance public safety, court integrity, and fairness to the defendant. Counseling may explain behavior, but it does not excuse it. And Michigan courts, especially under judges like Simpson, weigh compliance above everything else. The more the defense leans into the underlying issues argument, the more the judge will scrutinize whether those same issues will lead to yet another bond violation.
I mean, the address in our motion, but she was doing that until January of 2023. The way Ms. Vongfachan described that to me was I think some of the behavior the court has seen through the bond violations it's heard is that Ms. Vongphachan, for some reason, when confronted with an issue in her life, at first blush, her first reaction is maybe to be dishonest or wiggle out of a situation. And I think she sought help with that exact behavior before. So our primary argument in support of the court granting our motion would be so that Ms. Vongphachan could re-engage with that kind of counseling. Of course, Ms. Vongphachan is fully aware of what her bond conditions were and will remain fully aware of what those are if the court does grant our request. Ms. Vongphachan will or cease using any intoxicating substance during the pendency of this case. I know she wants to seek reemployment for the job that she lost as a result of her actions. And I think she acknowledges that the delay and the turbulent bond release she's had so far have been her own doing.
This moment is crucial because the defense openly acknowledges responsibility. Another strategic move, but responsibility alone does not guarantee leniency. Judges assign bond conditions with clear expectations, and in this case, the defendant has consistently dismantled every opportunity given to her. As the defense argues for reinstatement of her prior bond with an added alcohol tether, the real question becomes, is adding more technology going to fix a compliance issue that seems behavioral, not logistical? The scram tether can detect alcohol consumption, but it can't enforce better judgment. It can't stop her from violating no-contact orders. It can't keep her off social media. The judge knows this, and the audience can feel his patience wearing thin long before he verbalizes it. Here's your engagement question. Do you think adding another layer of monitoring is meaningful if the defendant ignores the rules anyway? Or is it a necessary compromise that gives her one last structured chance?
I think the time she spent in custody, she's had an opportunity to reflect and to think about how she wants to move forward. I think she wants to head in a positive manner towards resolving this case. And we would be asking the sentencing court to consider probation still. She knows that her bond violations are going to be considered by the sentencing court in determining sentence at the resolution of this case. So, Your Honor, what we're asking the court to do is reinstate her previous bond. We're asking the court to keep the previous bond conditions in full force and effect, and that the court modify her bond such that she be fitted with a scram alcohol tether prior to her release if the court grants our request.
Is there anything additional from the people?
The opportunity to review the counsel's motion and file a response to counsel is correct. I did not deny any of the allegations in there. The only additional information that I could include was my knowledge of the defendant's CPS case regarding her children. But at this point, I would leave her current status at the court's discretion. Thank you.
Was there anything you want to say to me?
I just want to say thank you for allowing me to have a motion hearing.
Tell me why I should let you out. Because, and there's a reason why I'm asking this, and so it's clear.
This is where Judge Simpson fully shifts from fact-finding to accountability mode. When he asks a defendant directly, "Why should I let you out?" he isn't asking for excuses. He's looking for insight, something that shows true understanding of the mess created. But instead, what follows is a pattern the judge recognizes instantly: minimizing, confusion, and a lack of foresight. The judge recaps her trajectory with surgical precision. A misdemeanor turned into a felony, bond chances thrown away, multiple violations, and now 3 solid weeks in jail over something that originally would have resulted in no jail time at all. That's the tragedy here. The defendant has essentially jail-timed herself through her own decisions, and the judge is visibly astonished. His rhetorical questions are not insults, they are warnings. His message is clear: if you can't follow simple rules, I cannot trust you with freedom. This is a turning point in the case, and it's one of the strongest moments of the entire hearing.
When the facts of the case were relayed to me last hearing that we were on, or the alleged facts, I should say, I'm amazed that you took something that was a misdemeanor. I don't want to call it a simple misdemeanor, but a misdemeanor. And something that more than likely you would have never spent any time in jail on. And somehow on the date of that offense, parlayed that into a felony charge, or at least a high court misdemeanor charge. I don't even understand how that happened. But even after you did that, then have a case that you still wouldn't have spent any time in jail. And all you had to do is just follow the rules. That's all you had to do. And then somehow or another, you've now spent 3 weeks in jail on something that you would have spent no time on whatsoever. And I don't get it. I really don't. I say all of that to say, I feel like this is almost Groundhog Day. I bring you back the first time after the first week, gonna let you out, find out what you've done while you've been in jail, can't let you out. You spend that second week. Then I come back the second week, I let you out. Don't make it a day before you broke the bond conditions. Then next thing you know, next time you come back in, I gotta throw you back in. And now here I am again. So it almost is that old saying, why should I repeat and do the same thing? Because that would be insanity on my part. Tell me why it wouldn't be.
This is the judge signaling he has reached his personal threshold. In judicial language, this is as close as it gets to saying, I am done giving chances. He reviews her repeated violations like a checklist of poor decision-making, and he's right. Releasing her again without new safeguards would look irrational. Judges must justify their decisions on the record, and he is building that justification line by line. For viewers, this is a perfect example of how bond is not just legal, it's psychological. If a judge feels burned, the next chance becomes exponentially harder to earn. And yet, he still asks her to persuade him. This is rare. Most judges would have shut the door. But here, he wants to see if there's any genuine remorse or evolution. Her answer, minimal, unconvincing, emotionally shallow, which only increases the tension in the room.
You tell me why I should take a chance on you.
I had some time to sit down and think for these past few weeks. I won't do it again.
You lost your job. You missed your kid's birthday. For what?
For my actions.
Did we print off that communication I received?
No, but I can't.
Counsel, I received an email, which I'll just widely to print off. I actually meant to have a copy here, and that's my fault, so that you could have that from, I guess, the father of their children, their partner. I don't know if you've seen that, whether that was sent. Daniel Gray, and I'll just indicate to you, I mean, I'll let you read it through, but as you read through it, the person that I am reading about in this is not the person that's been appeared before.
Yeah, Your Honor. Yes, I did.
Hmm?
Yes, I did, Your Honor.
Anything you want to say regarding that?
Your Honor, I do appreciate Mr. Gray's kind words about my client. I think one issue that Ms. Fonfichen has dealt with for probably her whole life, but at least since I've come to know her, is that she has a remarkably difficult time kind of opening up and
Of doing what?
opening up to people. And I think that's one of the reasons she was engaged in counseling before, was that it has taken us a long time to kind of develop an attorney-client relationship, just because There's something in Miss Fongfachan's past, I'm not sure what it is specifically, that has created a situation in Miss Fongfachan's life that she just has a difficult time kind of opening up and being truthful about what's going on with her, what her feelings are. And so I think the sentiments reflected here by Mr. Gray, who is presumably someone that Ms. Fongfachan has opened up to, probably give a more accurate picture of who she truly is than I can give to the court, or that even Ms. Fongfachan can provide to the court herself.
The defense humanizes her again, explaining emotional barriers she struggles to overcome. This is relevant not only to her past counseling, but to her failure to follow instructions. People with avoidance tendencies often delay communication, hide problems, or react impulsively, behaviors that do not mix well with court supervision. But legal systems cannot adjust themselves around emotional difficulty. Bond is binary, you follow it or you don't. And while trauma or emotional blocks may explain her silence, they do not excuse her choices. Still, this is one of the few moments where the courtroom softens. You can feel the judge listening, weighing whether this vulnerability is real or another performance. And viewers should ask themselves, is the defense revealing a meaningful truth or stretching to protect a client who keeps self-sabotaging?
Have you gone through with her what her bond conditions are, counsel?
Your Honor, I have, and I believe that the bond conditions that previously existed are clear to Ms. Fongfachan now, but I would give her an opportunity here on the record to ask if she needs any clarifications or additional explanation about what the terms of bond are.
No,
Are you certain?
sure.
Okay. And you understand that there has been no modification to the previously instated no contact order that allowed for limited contact with Mr. Gray for purposes of raising your children via text message. You understand that?
Yes.
Okay. Your Honor, something the court would, based on this correspondence, consider modifying today?
Modifying what?
The no contact order that was previously in place between my client and Mr. Gray?
No, I'm not, I'm not gonna do that. I mean, and here's my reason. I'm not trying to be harsh about it. But that condition was in place from the get-go, right? And, I think I indicated this to you, counsel, that when she came back and there were all those calls, I think I told you, because the communication regarding children was supposed to take place by text message, that I could even forgive a couple calls a day. I would just, without even knowing the content, I would just have to say she can't have that form of communication. But that's not even what happened. I mean, it's not even just about not following the rules. It's like she wants to play by her own rules.
This is one of Judge Simpson's most revealing lines. He isn't accusing her of confusion or misunderstanding. He's accusing her of deliberate non-compliance. And that distinction is everything. If a defendant doesn't understand rules, you educate them. If they don't like rules, you enforce them. But if they think they can customize their own rules, that's when judges react strongly. Her no-contact violation wasn't an accident. Her drinking wasn't a slip. Her social media appearance wasn't a misunderstanding. These were choices. Choices that went against explicit warnings. Here's your engagement question. If someone repeatedly ignores restrictions that are designed to protect themselves and others, should they be trusted with bond again? The judge clearly thinks the answer is no, and yet, he hasn't ruled out giving her another chance.
And I hope she understands this is what you get when you play by your own rules and they come in contradiction to the court rules. This is what you get. So I'm not going to change anything. I just want her to follow what was originally set. Just do that. and I can be happy.
Understood, Your Honor.
And don't say you don't know. Chuck, don't say, I didn't know I couldn't drink. You got an attorney. You can ask your attorney, can I do this? After I threw you in jail for 2 weeks, it would seem to me that the first thing I would have asked my attorney on getting out or before is, what can I not do? But you didn't do that. That next day you were drinking. Do you still have a job even?
No,
So what are you gonna do?
I don't have a job. Like, I lost my job, but on the weekends, I throw a party on Saturdays.
Your Honor, I think what Ms. Bonfachan means to say is she was in the business of
Pardon?
promoting events and parties.
I know, and that becomes a problem because you just made this a mess.
Your Honor, I think if she's on a scram tether, she would refrain from partaking in any activities that would violate court's orders. She would, of course, still be subject to the drug testing requirement that was previously in place. I understand that environment.
But these things are promoted on the internet.
They are.
And one of the conditions I was going to have is that she can't appear vocal, oral, or otherwise on the internet. So how's she do what she was doing without doing that?
Ms. Bonfachan, is it possible for you to continue the business you're in without using Instagram or other social media as a way to promote your business?
I guess I just have to stop.
Okay, but is it possible for you to continue your promoting business without using social media?
And that's how we promote the party. So,
Okay,
no.
Oh, dear God.
This exchange is almost surreal. The judge asks if she can continue her event promotion job without social media, and she essentially says no. In other words, complying with court orders destroys her business model, but violating the orders risks jail. This puts the judge in a corner. Does he accommodate her livelihood, or does he prioritize courtroom integrity? Her answer, I guess I just have to stop, feels more like resignation than responsibility. She isn't strategizing long-term change, she's reacting in the moment, and Judge Simpson sees that instantly. Her inability to problem-solve independently is part of why she keeps violating bond. This moment perfectly illustrates the tension between personal life and legal obligations, and it shows why some defendants struggle even when conditions seem simple on paper.
are you able to seek other employment or
I'll
reemployment at
look
your
for another
previous
job.
job?
I'll look for
Okay.
another job.
Are you able to get in contact with your union representative of the to see if there are ways that you can seek reemployment where you previously were working?
Possibly.
Okay.
You know, ma'am. Frankly, for the most part, had you gone on social media after being in court, I could have cared less. But it's what you did when you went on.
Understand?
What was in your head to call from Washington County Jail? Really, what?
I don't know.
What? No, you had to have. Don't tell me I don't know. What the heck were you thinking? Have you heard yourself on that podcast when you call from the jail?
I haven't. I heard one clip, but I haven't watched it.
Stupidest thing ever. I'm gonna tell you what, man. You better thank that man standing next to you. Because I'm gonna be absolutely honest with you. The way I am, if you had, I'd be so done. And you just wouldn't see the light of day. if it weren't for what arguments he was giving me, and at least the faith and hope that he has in you that you can just do the right thing for once. He has that faith. I'm not sure I do. But he's convinced me. I'm going to give you another shot. God help me if you had come back. God help you. Because I don't know who's going to. I'll reduce the defendant's bond to a $25,000 personal recognizance bond. I'm going to add all previous conditions that were originally set are reinstated. You understand that?
Yes, Your Honor. Thank you.
There's to be no appearance, or vocal, oral, or otherwise on any social media platform. Defendant is to be placed on a scram tether prior to release. All right. Now let me explain something. You know about the scram tether?
I just know not to drink alcohol.
Yeah, I think we figured that one out. Right? Now, if it comes back and you violate, so the reason I'm not just putting on a sober link where you have to blow is because you don't know how to follow any rules. And that requires blowing 3 times a day. And I know darn well before the week is ended, you will not have done that because you just can't. At some point, you get so stubborn and you just say, I'm not going to blow into this thing. And then we're back here. So I'm trying to avoid that. If it comes back with anything, consumption of alcohol, I'll listen to you, but it's going to be really hard to convince me you didn't do it. Am I understood?
Yes.
Green, please, let's see if we can just make it to the 23rd without any further incident.
We're going for absolute best, Your Honor.
The what?
We assure the court we will.
I will.
There will be no issues of bond on 423 is what Ms.
I
Bonfajan.
heard that 3 times before.
Thank you.
Thank you. Only if you- Oh. You thought I would? I was going.
This is the closing movement of the hearing, and it's one of the most dramatic finales Judge Simpson has delivered in recent months. Despite everything, the violations, the podcast incident, the drinking, the no-contact breaches, the disregard for rules, he still gives her one final opportunity. But he makes it unmistakably clear. If she comes back again, it won't just be bad. It will be catastrophic. His trust is paper thin, and the scram tether is his last barrier between order and chaos. Legally, this is a calculated risk. The judge lowers the bond to a $25,000 PR bond, reinstates all prior conditions, and adds a technology safeguard to reduce temptation. He outlines consequences with precision, reminding her that this is her final chance. Whether she succeeds or collapses under pressure remains unknown, but the stakes are now unmistakably high. If you found this case as shocking as we did, hit like, share your thoughts in the comments, and subscribe for more intense courtroom breakdowns.